Today, we're going to talk about disclosing prior reports, deaths on property, Megan's Law, flipped property rules, and a little bit more. I thought this was pretty relevant, especially with the flipped property, because, either you're running across flipped property on the buyer end, and maybe you feel like they're not disclosing what they're supposed to be disclosing. So we will, touch on that as well. Um, and then the disclosing prior reports. This is becoming a lot more prevalent, I'm seeing. I mean, it's been a thing, but I am starting to see listing agents share prior reports from even a couple years back a little more often now, which is a good practice. And we're going to go through and see why. Disclosing prior reports of repairs. So while almost everyone's familiar with the standard rule, when in doubt, disclose, there are still circumstances that can trip up an otherwise diligent agent. Sellers and agents each have an independent duty to disclose all material facts that affect the value and desirability of the property. While this rule may seem simple, mistakes they made all the time. So here are some things to look out for. I took a lot of snippets out of the RPA and different things like that we can share. Um, do previous defects have to be disclosed if they have already been repaired? I have had this question come up. The answer is a yes. Even if the problem or defect that existed in the past has been repaired, it's still a material fact that must be disclosed. So problems can reoccur, and buyers should know what to look out for in the future. So Section 4 of the SPQ states this in bold font. So if you're looking at the SPQ and you're having your seller fill out the SPQ, and I mean, we had one last week where the seller just marked no on everything, and they were in a condo. So obviously there's going to be some yeses there just by default of being in a condo. Um, and so, I asked the agent to have them actually take their time. We talked about a few things and to uh, basically do a better job at their disclosure. But you'll see number 4 here on the SPQ, seller awareness. For each statement below, they answer the question, are you, the seller, aware of? And then by checking either yes or no, a yes answer is appropriate no matter how long ago the item being asked about happened or was documented, unless otherwise specified. So there's no time limit. It's not 2 years, it's not 3 years, it's not a statute of limitations. If that water heater blew 10 years ago and you got a new one, for the SPQ and the law, it needs to be disclosed to the homeowner. So I like to always tell the homeowner, the state of California wants the buyer to know everything you know about this home. And that's essentially how they um, have the laws and everything, and all of our disclosures are geared that way. So furthermore, the SPQ asks questions specifically about repairs and alterations made to the property. Paragraph 7 of the SPQ asks the seller to disclose any alterations, modifications, replacements, yada, 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 as well as any ongoing maintenance. And this is the whole section 7 here. Excuse me. So it asks them a bunch of questions, and yeah, if they check yes, they have to give an explanation, and it doesn't have to be a paragraph long explanation. It's what happened and how was it remedied, if at all. That's really what they're looking for. Actual scenario, we had this come up. City has noted there are violations with the property or building. Seller directly spoke with the city inspector, but a copy was not formally delivered to the seller, and or the incorrect name was on the violation document, but the correct address. Would the seller still be obligated to disclose this if they never received a formal notice from the city and or the notice was in the incorrect owner name on the document? So this actually came up, and The answer is a yes, because it's a material fact. This is a material fact that needs to be disclosed as the seller has knowledge that the city found violations, even if it was a verbal communication. And Section 6K of the SPQ can be used to address this scenario. So, yeah, basically the seller was like, well, yeah, as we're kind of getting through, and this happened to be a post-closing complaint, which we've been talking about lately. And yeah, the buyer had found out, because the city came and they're like, hey, there's things that need to be corrected here. They found out that the seller had had a conversation with the city inspector. When asked, the seller was like, oh, yeah, but it was verbal. And then they sent a notice, but it was in the wrong name, so I just disregarded it. But that was a material fact. You had a conversation, they told you what was supposed to be corrected, and you didn't relay that to the buyer or you didn't disclose it. So that was a problem on their end. That's just a snippet of the SPQ again. And again, here's the 6K material facts or defects affecting the property not otherwise disclosed to buyer. So it'd be yes or no. So this is basically covering anything else that's not in the SPQ or TDS. Additionally, 11N of the RPA has a provision that the seller agrees to a term of the purchase stating they agree to disclose all known material facts and defects. By agreeing to the terms of the RPA, the seller is agreeing or otherwise binding themselves to the obligation to disclose. So not only, you can point that out in the RPA as well. If you're going on a listing, maybe maybe you feel they're not being 100% truthful on things, you can show them in the RPA, look, you will be bound to do this anyways, just by the terms of the RPA. So there's lots of different ways that you can show the seriousness of this with your homeowner. And this is paragraph 11A, known material facts. So this is a snippet from the actual RPA. Seller shall, and if you remember when we had the attorney on, shall is the strongest term, within the time specified in paragraph 3N, 1, disclose known material facts and defects affecting the property. So, yeah. Next up, do sellers and or agents have to provide copies of inspection reports or other documents in their possession relating to the condition of the property? Most everybody knows this by now, but yes, if you get into escrow, buyer does inspections, ends up canceling for whatever reason, the buyer, contractually within the RPA, is supposed to turn those over to the seller because those are now material facts, and that needs to be provided along with the disclosures now. So if they had multiple inspections, if they had the general inspection come over and a termite, and then maybe from that it stemmed into maybe a plumbing inspection and a roof, all of those would need to be turned over to the buyer at that point. Again, section 14A of the RPA addresses this obligation. 14A, seller delivery documents seller shall within the time specified deliver to buyer all reports, disclosure, and information, in quotes, reports for the seller is responsible as specified in multiple parts of the RPA. So also paragraph 5 of the SPQ specifically asks the seller about any reports, inspections, disclosures, warranties, maintenance recommendations, so on and so forth, pertaining to the condition and the repair of the property, and instructs the seller to provide copies of these documents in their possession. So when you're going through the disclosures, with your homeowners, and you send them everything, maybe you're sending it through DocuSign, you're like, hey, take your time, fill these out. Maybe you give them a quick overview of it. When they send it back, you're going to want to just give it a once over for sure. And, when they have marked yes on certain things, and for one, you need to make sure that they provided the explanation, but for two, ask them if they have the documentation from whatever it was that happened, because it's going to get asked for from the buyer. Now, the seller doesn't always keep every little receipt and work order and stuff like that, but if they have anything, it does need to be turned over And so you might as well collect it at that point because it's going to be asked for, or it should be. The buyer's agent's doing their job. All right. Does a disclosure have to be made no matter how long ago the repair took place or how old the document is? Yeah, seller's agent should try not to determine whether something is too old or happened too long ago to be considered material. If the seller has knowledge of the repair or still has a copy of that report, those things should be disclosed to no matter how far back they go. Of course, the older report document is, the less useful it is to the buyer, but ultimately what you're trying to do is reduce risk. And so you can't have the buyer coming back saying, oh, the neighbor across the street's lived there forever. And they said 10 years ago, you know, there was a small fire in the garage or something like that. It's always the neighbors that you really got to worry about. Those are the ones that spill the beans. So seller awareness. So again, here we are in the SPQ, no matter how long ago. Best practice buyer's agents should note the dates of the reports or other documents being provided and point out to the buyer that they are significantly out of date. Do real estate licensees have to keep documents relating to the property? What about the property owners? Answer is yes and no. So real estate licensees are required by the Department of Real Estate to maintain records pertaining to transactions for at least 3 years after a transaction closes. And that's their wording, at least 3 years. So 3 is the minimum. And maybe you're keeping stuff a little longer. I know there's various statutes of limitations out there, but I've still come across a few instances where things are very old and all of a sudden there's like something springing up many years later. Therefore, if an agent helped a client buy a property and is now listing that property within a 3-year period, all documents related to the property from the time of purchase would be expected to be in possession of and therefore disclosed by that agent. So this is kind of putting it on to the agent at that point of if you have worked with this client, maybe you sold them the house and I don't know, 2.5, 3 years later, whatever, they are getting relocated. Maybe they're in the military getting stationed somewhere, who knows? But they decide they don't want to sell the house and they come back to you, hopefully, to be their listing agent. Technically, you should be in possession of the original disclosures. And that's how the court would see it as well. So the best practice, this should be a topic brought up to the seller. So they are aware that you as the listing agent have an obligation to provide these prior documents from when the seller purchased to the new prospective buyer. However, while many sellers may have held on to property reports, they have no legal obligation to do so. So they don't have an obligation to retain anything for 3 years or any amount of time. They can just, toss that receipt right in the trash as soon as they have the work done or whatever. But as licensees, we are required to have them for 3 years. I think we had a couple things come up in Q&A real quick. Let me just double check. Okay, so one question here. What is your opinion on having a seller do a pre-listing property inspection? In my opinion, it gives the seller knowledge of items, issues they may have had no knowledge of prior to. And it is a good practice, and our Northern California agents are probably accustomed to this because it is very common in the northern part of California to do the pre-listing inspections and all of the disclosures and upload it all into MLS or a link where it is stored, Dropbox or HomeLight or whatever. And basically the buyer's agent reviews all of that stuff and they will essentially have gone through all those documents prior to even making the offer. So it is technically a good practice if the seller is willing to pay for that home inspection to be provided. Obviously, the buyer would still have the right and probably be encouraged to get their own inspection from an inspector that they choose. And I guess from there, they can make a comparison So we don't want to take that right away from the homeowner, but basically you're saying, here's the condition of the property up front, make your offer accordingly. So I'm not against it. Next question. I've always told the seller, disclose everything you know about the property, bar none. Yep. So state of California wants the buyer to know everything you know about this house. So, all right, let's get back. Real estate licenses are required. Oh, we already went through all that. Best practice. Okay. Is a listing agent or seller who is in possession of an inspection report that was paid for and obtained by a previous buyer required to disclose, even if that report contains language saying that the report may only be used by the person for whom the report was repaired. And you might find home inspection reports that have this language. And actually, the answer is yes. Many inspection reports contain this language, limiting their use to the person who paid for the inspection or describing the report as non-transferable. This language is there to protect the inspector and let third parties know they should not expect to have claims against the inspector for any reason. Such disclaimers do not make the report confidential. And once it is in the possession of the seller or listing agent, it must be disclosed to any subsequent buyers of the property. So the law supersedes the language that is in those reports. All right, so let's move on to flipper disclosures for properties resold within 18 months. So this was a recent bill that got passed. It was effective in July of last year. It's AB 968 if you want to research it at all. So yeah, July 1st, 2024 is when it went into effect. So we're coming up, shortly on a year of this. Flippers, in quotes, of residential 1 to 4 properties must disclose recent repairs and renovations to the property in addition to all other existing disclosures. So this applies to properties that are resold within 18 months of closing. Standard TDS categories, exemptions, and cancellation rights apply. Applies to transactions if it's a residential 1 to 4 unit. Seller accepts an offer within 18 months from the date that the title to the property was transferred to the seller, and renovations or repairs were performed by a contractor with whom the seller entered a contract. Requires the seller to disclose to the buyer any room additions, structural modifications, other alterations, repairs, and a copy of any permits if obtained. Or if the seller contracted with a third party and was not provided with a copy of any permits, the seller may inform the buyer that the permits may be obtained through the third party and provide their contact information. These disclosures may alternatively be disclosed as a list given by the contractor to the seller. Additionally, where the cost of labor and materials was greater than $500, the seller will disclose the name of each contractor, the contact information for each contractor as provided to the seller. So that's really probably the most important one there is providing the names of who has done the work and the contact information if available, which they should have it available if they've, if they've just got this home remodeled. So, and this can be all added into like an addendum to the SPQ or something like that. That's fine. You can list all this stuff out. TDS application, exemptions, and cancellation rights. This disclosure comes within the transfer disclosure statement law. It applies in the same circumstances as a TDS. It has the same exemptions, and it is the same subject to the same cancellation rights as the TDS and TDS related disclosures. The SPQ already requires sellers to meet most of these new disclosure requirements. You can see right here in the SPQ, they did update it at that time when they passed this law or shortly after. It's 7F, whether you purchase a property with 18 months of accepting an offer to sell it, yes or no. If yes, and then kind of go on from there. And then they're going to want to probably attach an addendum to this if they need to explain or write down a lot of contractors' information or anything like that. So that's a big one. If you're not getting this stuff when you're on the buyer's end, you should be requesting it. You should be pointing this out. You can reference the actual bill, AB 968, and make the listing agent aware that this is a requirement. So next up, disclosing death on a property. It doesn't come up a lot, but I've gotten some occasional questions on this, so I figured we'd go over it. Sellers are required to disclose a lot of information when selling the property. Specifically, they must disclose all material facts relating to the value and desirability of the property. Beyond that, sellers must also answer certain questions that are asked on various disclosure forms required. Many sellers are surprised to learn that they must disclose information relating to a death that has occurred on the property. Here are the requirements for disclosures related to a death on property. So the seller must disclose any death relating to the property if the death occurred on the property, the deceased was an occupant of the property, and or the death occurred within the past 3 years. Where should this information be disclosed? Question 6A of the SPQ and 3A of the exempt seller disclosure. So that would be used in certain trust sales and things like that. So you'll see SPQ 6A, ESD, which is the exempt seller disclosure, is 3A. If the answer to the question is yes, should the seller check the box and use the space below to provide additional information, such as the manner of death? Are there any exceptions to the death disclosure requirement? If the cause of death was related to HIV or AIDS, then that information must not be disclosed. So that's a little nugget that not everybody knows about. What happens if a buyer or buyer's agent asks about death on the property? The seller or listing agent may not make any misrepresentations regarding the property. If asked directly, a seller or listing agent must answer honestly about any deaths that have occurred on the property, no matter how long ago. Are there circumstances where a seller may want to disclose a death that occurred on property more than 3 years ago, where the deceased was not an occupant of the property? The answer is yes. Even if the death doesn't meet the criteria to warrant a yes answer on the disclosure forms, a seller may want to disclose the death if it is particularly notorious or has stigmatized the property such that it may have affected the property's value or desirability. You may know of homes like this in your community. I know of one. We had kind of a high profile one where a wife had murdered her husband in the house, and it kind of was a huge thing in our community. It was actually not too far from my house, nice suburban area in Carlsbad, and I actually believe that she was a realtor, and the story went on for many years, lots of follow-ups and stuff like that. It's been well past 3 years, but the people in the community are aware of this story and the community that it happened in. And so if this home were to come up for sale now, I would say that that listing agent should probably disclose that if they know about that. So, and they're gonna probably know about it because I'm sure a neighbor is gonna walk over and say something at their open house. So that would be an example of when you would want to do it past 3 years, because that was kind of a notorious thing that happened in the community, and had lots of media coverage and everything. So thought I'd throw in haunted houses. So while on the topic of disclosing nuances that may affect value or desirability, what about a haunted house? Do you have to disclose that the house is haunted? So the Civil Code does not specifically address alleged haunted houses. So in extreme cases there where the property is in some way stigmatized, such as being haunted, the seller may be obligated to disclose the stigmatization where it constitutes a material fact, particularly in the value of the property is diminished by such a fact. So again, maybe there's a house that's, the community believes is haunted or whatever. That would be one where you would want to disclose that. There is case law to support this. It was in New York, but they ruled the seller had a duty to inform the buyer of the possible existence of poltergeist or spectral apparitions where the buyer alleged that the market value of the property had been greatly diminished. And because essentially the desirability of that property probably was diminished is what happened, because a lot of people may not want to move into that home, which is going to affect the value. In this case, the house had a long established reputation as a haunted house, and perhaps more significantly, the seller had previously reported the ghostly presence of the house in both national and local publications. So in that ruling, the judge cited the fact that the seller had disseminated the information to the public to explain why such non-disclosure would violate principles of equity. Another possible way in which a stigmatization may constitute a material fact having to be disclosed is if the property continues to be affected in its present day. For example, if we imagine the OJ property in which tourists visit the property as part of a bus tour, such a circumstance should be disclosed. So again, when in doubt, disclose. So yeah, if it's on a haunted house tour, you're definitely going to want to, make sure that that is disclosed. And that's definitely a rare one. I don't know that I've run across a haunted house yet. Maybe you guys have. Megan's Law. So I'm putting this one in here because we had this question come up last week, and I also have a little story behind this as well. So if an agent is aware of a specific person on the Megan's Law living nearby, may that information be disclosed to a buyer or seller if it is believed that the buyers might have children? So the answer is yes. It may be disclosed as long as there is a reasonable and good faith belief that doing so will help protect a person at risk. It is not necessary to ascertain a specific identifiable person who is at risk before information on the Megan's Law database may be disclosed. What are the disclosure obligations of a seller of real property regarding a sex offender in the neighborhood? If a seller of a real property must disclose all known material facts affecting either value or desirability of a property, if the buyer is unaware of these facts and the buyer would not learn of the information. If the seller actually knows that a registered sex offender resides in the neighborhood, she should disclose the information to the buyer to avoid potential costly litigation. In addition, the Civil Code requires that the following notice be given to a purchaser of residential 1 to 4 units. And so this is in our RPA. It's also on the DBD form, which is the Megan's Law database advisory, which is just a little one-pager. It says, what it is and where you can find information. Upon delivery of the written notice, the seller or broker is not required to provide additional information regarding the proximity of registered sex offenders. In addition, the information in the notice will not give rise to any cause of action against the disclosing party by a registered sex offender. This law does not alter any existing duty of the seller or broker under any law, including a duty under any existing disclosure provision. So I bring this up, and sometimes you guys ask, why do I have the Megan's Law database form on our pipeline checklist? And the reason why is because this notice here that they incorporated into the RPA is so buried down in there. I mean, nobody even reads through that stuff. You get past the grid section and everybody's just click, 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 right? The reason why I like to add in the DBD form is because it brings attention when there's just one document here that they have to stop on. And so I believe that that is a better way to advise the clients that they should go search his database if they have a concern about this. We had two instances. I'm going to share one where we were on the buyer side. We bought, we closed on the house, and afterwards, I think it was again a neighbor, it's always the pesky neighbors, had said something to the buyer about the seller actually being on a registered sex offender. And this was a real problem for the buyer because the buyer was in education and they were kind of freaking out that because the home had been tagged essentially as having a sex offender in it, that it was going to affect their employment. Now, everything got resolved, it was fine, but if they had known to check the Megan's Law database, or if they had been advised a little more strongly about it, they were advised. I mean, it's in the disclosures and the RPA that they signed, but if they were maybe advised a little better on it, and having that form signed separately, they potentially may not have bought that home. We don't know, but or they may have wanted a few things done to reassure them that when they took possession, that it was going to be off of that registry. So that's why I wanted to go over Megan's Law and why, why we have it in there as a separate line item in our pipeline file is because these little instances do come up. So we're going to continue. What is the best way to comply with the Megan's Law disclosure requirement? The CAR forms have the most current statutorily required Megan's Law notice. So you don't need to do anything else, just provide the notices. What is a real estate broker's agent's duty of disclosure under Megan's Law? Once a specified notice is given, the notice is deemed to be sufficient to notify the buyer of the statewide database. Real estate brokers are not required to provide any other information regarding the proximity of a registered sex offender, absent actual knowledge. What disclosures are required if either the seller or the broker is actually aware of a registered sex offender living in the area? Both the seller and the broker have a duty to disclose material facts under California law. Under the Civil Code, providing the notice of existence of the Megan's Law database does not insulate either the seller or the broker from otherwise disclosing a material fact of which either is aware. Based on these standards, the answer depends on the exact facts and circumstances regarding the information known. In most circumstances, the information should be disclosed to the buyer. This should be disclosed as long as there is a reasonable and good faith belief that doing so will help protect a person at risk. It is not necessary to ascertain a specific identifiable person who is at risk before information on the database may be disclosed. And we'll wrap it up. What disclosures are required if the broker learns that the buyer is a registered sex offender? Actually, I have not had this come up, but I thought I'd share. The buyer's broker probably would not be required to disclose that the buyer is a registered sex offender. It would likely not be a material fact to the seller, nor impact the sale of the property from the seller's perspective. Since the buyer's broker has a fiduciary duty to the buyer, then the broker probably should not disclose this information, as it might be a breach of his or her duty to the client. So, we're wrapped up in good time. Yeah, hopefully that helps. Please pay attention, especially to the flipper rules. Those are the ones that are probably the most prevalent right now. There's a fair amount of flip properties on the market at any given time. And if you are working with an investor or if you are working with a client buying a flipped property, you want to make sure that these things are being covered, because you don't want the buyer to come back in either scenario saying these things weren't disclosed. They should have known. They remodeled the house. they have disclosures from the previous, so on and so forth. So pay attention to these. I can share this document if you want in the replay in our Facebook group. We'll throw it into the comments section as usual if you want to just have this for reference. Or you can simply just Google the AB 968 if you want to read up on the flipper disclosures, especially if you're working with a lot of flippers or you yourself are flipping properties. So that's about all I have for today. I think I covered all the questions. Yep. So if there's no other questions, I say we can go ahead and get on with our week. Thank you for attending. We'll be back next week. And if you have any questions on anything, always give me a call. Otherwise, I hope everybody has a great week. We'll talk to you soon.